Welcome to Dolly Talk. This is Dolly. How is everybody doing? First and weekend. T-Bone. How you doing, by Franz? I was not late and gay when you said that. I was 1 minute later. I was hoping my Walmart delivery would be here by now, but no, of course not. Angie's here. How is everybody? Hey, Factual Lie. How you doing? All right, so we are going to start with some Judge Simpson and go from there. I did not yet. I will check it out either tonight or tomorrow. But I haven't had a chance. I just got home from work a bit ago, so should be interesting. All right. So I'm going to start this. If I have to step away for like 1-2 minutes, I'll be right back. I just have to get the door for Olga, who's delivering my Walmart. Because I'm a fancy person.
Record to reflect we had a bench conference in this case. Regarding the restrictions, I'm going to indicate that she's not to enter the any University of Michigan property except for medical care.
Thank you very much, Your Honor.
Okay, and so that I can also make the record clear, I am taking no action regarding the To coalition or any restriction regarding that. If the court, so that everybody, where after exam were to determine some connection where the court would need to place a restriction, then certainly the court may do that. But at this point, I don't see that connection.
Thank you, Judge.
Okay. Anything else?
Nothing more for defense. Thank you, Judge.
Thank
No,
you.
Your Honor, thank you.
Thank you, folks. Okay. I think that's it. Okay, that does that one.
All right. Thank you.
All right.
Have a great day, you and your staff, Your Honor.
Too late, but thank you. Can you send a message to the magistrate that the other case should also be set for Pete? You already did it? I hate that when you're running around in my head. Okay. Okay. Court does call the case, People versus Lauren Brown. Well, hold on a moment.
That one.
What's the matter?
Is this something I did?
Probably.
Whoa. I don't want to be near that ton, guys. I'm just going to get to the other side of the screen. Ooh.
There she is. Okay. I wanted to make sure she could make it up here. All right.
Yeah.
Go ahead, counsel. You're here.
Good afternoon, Your Honor. Mark Hyder on behalf of Lauren Brown, who stands to my right.
All right. And your name, ma'am?
Lauren Brown.
All right. You're waiving preliminary examination.
That's correct, Your Honor.
And you understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right. Preliminary examination having been waived, defendant is bound over circuit court on counts 1 and 2 with 3 following. Counsel, go ahead.
Waive the reading standing, Your Honor.
Defendant having waived formal reading, standing mute to all 3 charges. Court will enter not guilty plea. Pretrial will be set for
March 10th at 1:30 p.m. with Judge Simpson.
March 10th, 2025, 1:30 before Judge Hammoud.
Thank you very much, Your Honor.
Thank
Judge
you.
Hammoud.
Your Honor.
Bond continued.
Okay.
Court calls the case People versus John Cahill.
Counsel, I'll for the people.
Your Honor, good afternoon. Joe Simon on behalf of Mr. Cahill, who should be appearing by Zoom.
You have him?
Oh, God.
We had him earlier, I thought. Your Honor, Mr. Cahill is the person in the medical
on.
facility, and
Right.
his nephew tries to use a cell phone there, and from time to time that signal isn't stable.
No excuses, sir.
All right.
You're right, request a bench conference on this matter, just very briefly, I know it's been a long day, but
Oh, God. I don't care if he's in the hospital.
Are
Oh,
you there?
Well, if he's faking, that's a pretty good impression he's doing. How?
Hang on. Hang on, Mr. Cahill, okay? Just one moment. We'll be right back with you.
I'd love for
Okay.
the judge to accuse him of faking, and he has to like whip out his catheter. Unless he knew he was going to piss hot, so he ran to the ER saying, "I've got chest pains and can't breathe." Do they buy it, son? Plot twist, this guy's actually like some huge gangster, and he actually designed his bedroom to look like a hospital just to screw with judges. So you see, Judge, I'm gonna piss a little hot on my oxycodone test.
I got the color. Record should reflect it at bench conference.
Okay. Judge, you're muted, Judge. Hey, Christine. What are we doing? Come on, guys. Chop, chop. For Christ's sake, this woman, Olga, cannot get her act together when it comes to Walmart deliveries.
Thank you, Mr. Cahill. It's February 6th.
February 6th? What am I going to be doing then? Oh, yeah, I'll be dead.
Good. I'm on. All right.
Can you hear him?
Yes, we can hear you. Can you hear us?
Yes.
All right. So I've adjourned it out to February 6th. Okay.
Okay.
All right. And Bond will
Okay.
continue. We'll see you then. Okay. Thank you.
Well, Judge,
Okay.
I don't...
You're
I-
welcome. Have a good day.
You
He doesn't
too.
sound sick.
Court does call the case of the people versus Phillip Krick.
as and on behalf of the people,
In your honor, Joe Simon on behalf of Mr. Carrick, go ahead and state your name.
Phillip K.
All right. And you just got discovery and you need to, all right.
Supplemental discovery has just been tendered, and there's probably a little more, yes.
and that's correct, Your Honor. And if we could address one condition of bond, Your Honor.
Yes.
I believe the tether radius is set to 600 feet. The victim was requesting that it be set to 1 mile for the exclusion zone.
Ms. Zen informed me of that before.
Is this guy considered like a modeling career for men? I'm just saying, he might be like a criminal, but he could definitely do some just for men commercials.
The docket, and we don't really have a problem with that. But my client is checked, and he said that covers stretches of I-94 that he travels. So we certainly don't object to the mentality behind the request.
I'm not simping
Well-
on him.
Folks, maybe you guys can help me here because as I'm looking at the I don't know where the,
Oh, God, math. They said there wouldn't be math today.
yes, the center point, maybe, hang on, let me,
Oh, God, now I got to get the pi out and the circumference. I'm just a simple lawyer. I don't do math. Now I need a tape measure to do the little guide thing at the bottom of the map.
well, let me, 100 there.
Oh,
If the center point is on that, yes, it's definitely going to hit 94. There's not.
I think.
With the address that I have here of Ferris Street, within a mile, you're going to hit part of 94 for certain.
I chose a bad spot to stalk
Is
that woman.
there a particular area that you want excluded other than the 1 mile, or is the issue the ability, notification and ability to then vacate?
I think it's the, well,
Nobody told me if I stalked a woman, I'd then get a restraining
so
order
what
from the
we
interstate.
received from the victim is she was saying she wanted the 1 mile radius around, I believe, the home address, because the defendant may be in places close to that, given the 600 feet, and she would rather have the
Notification, gotcha. Okay. Mr. Simon, did you have any?
Yeah, there's been no violations since his tether's been installed. And I definitely understand the mentality request, but going out a mile unfortunately puts him too much at peril. Maybe increases it to 750 feet. I'm not trying to be insulting. I'm just trying to make a compromise that addresses the concern and still keeps.
Let me ask this, is there any reason he needs to be in the city of Ipsy?
Yeah, his mother lives there.
Oh, his mother. Aw.
She like you? I'm kidding. Yeah, don't answer that. In the city itself, or is she outside of the
mother?
city?
Township.
Township. Okay. Because what I was going to do is I was just going to say he can't be in Ipsy City. That would seem to me to resolve it. If she's in the township and he can get into the township around the city of Ipsy.
Well, can you avoid that?
I mean, if I have to.
He does have people he knows there and visits there, but and I'm asking if he can.
It's amazing.
Can that be avoided for?
No, it can be avoided.
My client said he can make arrangements to
Make
abide.
it work. All right.
He's a mama's
Then what I'm
boy.
going to do is I'm going to increase the
God.
You can act like a man!
zone
What's the matter with you?
for GPS to include the city of Ypsilanti. I think we're going to need an amended order.
Wow. For what? Here in Pittsfield Township is where you live, so I can't go east. Go on 94. Come this way, go on 94. Right. I mean, you can still, he's checking up the city.
Sir, have you tried considering hiring David
Thank
Helm?
you.
And then we were going to turn this out with February 6th work.
Well, for me,
Pratt.
All right. Probable cause conference, February 6th, 2025, 9 a.m. Or as your invite indicates. Bond will continue, and we will prepare the order regarding the exclusion zone being the city of Ypsilanti.
Thank you, Your Honor.
Thank you.
thank you, Your Honor. Wait from the outside.
Hey, my food's
Court
here.
calls case of the people versus, is it Eozhen?
The ocean. The ocean?
Your Honor, Joe Simon on behalf of Mr. Shen, state your name.
Eozhen, Your Honor.
All right, thank you.
Requesting the matter be set for preliminary exam, Your Honor.
All right.
I heard the ocean.
Discovery is complete, I presume.
Yes.
People, other witnesses available the 28th.
I believe so, Your Honor. Thank you.
All right.
Middle name is Pacific.
Preliminary examination will be set January 28th, 2025. 9 a.m. before Judge Washington.
Speaking of colorful names.
Bond will continue.
Oh, boy.
Okay.
Thank you.
Thank you, Your Honor.
I wonder what the hell he
Court
did.
calls case People versus Eozhen and Joe.
Your Honor, Joe Simon on behalf of Mr. Joe.
Why were you not again?
Oh, it's perfect. You got it right on.
I'm always perfect.
Yeah.
I'll be right back, guys.
My name is Eozhen.
Wait,
All right, you're
does this
requesting
guy
an
just
adjournment
set up in
for additional
Chinatown?
Discover.
Yes, in this case, Your Honor, I wonder if we can go just a little bit beyond the February 6th PCC date. Could we do the
If neither
13th?
party has an objection, I'm not going to have a problem.
No objection, Your Honor.
All right. How much did you need?
The-
2 more weeks beyond that, or the
13th, I think should work, but
should work?
there's some coordination that we have to do.
Probable cause conference then will be adjourned to February 13th, 2024, 25, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you. Thank you, sir. Court calls the case People versus John Burgess. Was that it for the Simon Hour? Okay, wow.
Good afternoon, Your Honor. Good afternoon, Your Honor. Allison Castles, Beer and Law Group on behalf of Mr. Burgess.
Why is he here?
He's got a case this time.
I should make him leave the room. No, go ahead. All right. Your name, sir?
John C. Burgess.
Thank you. All right. What are we doing on this case?
We would waive preliminary exam.
Who's going to wait? All right. Sir, is that a correct statement? You're waiving preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right? Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts. Counsel, you.
All right. And as to arraignment, sir?
Yes.
All right. We would waive reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all charges. Pretrial in this matter will be set for
March 11th at 1:30 p.m. with Judge Combs.
March 11, 2025, 1:30 for Judge Combs. Bond will continue with its conditions. All right.
Thank you, Your
Thank
Honor.
you. Thank you. Court calls the case of People versus Matthew Ericson.
Afternoon, Your Honor. Dan Gare on behalf of Matthew Ericson. Matthew, can you state your name?
Matthew Ericson, Your Honor. Thank you. You're requesting an adjournment.
I am, Your Honor, and if possible, to the 13th, Ms. Brzezowski and I have a lot of work to do in the background.
Any objection? You concur in that? All right. Probable cause conference, February 13th, 2025. 9 a.m. as your invite indicates, bond will continue.
Thank you.
All right, thank you. Court does call the case People versus Jerry Bigam.
Epsilon for the people.
Kyle Burdell on behalf of Mr. Bigam. Mr. Bigam, please state your name for the court.
Jerry Bigam.
So today's date and time set for probable cause conference. We are still waiting on video. I know APA Londi is doing her part to get it, but was just not here yet, so we need a little more time.
Wait,
That's correct, Your Honor.
All right. Probable cause conference will be adjourned.
I'm back. What has chat gone up to? Okay, you guys are just being degenerate as always. Okay.
Adjourned February 6th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Judge.
Thank you.
Why the hell did I just get 20% more viewers when I went away? Huh.
Court calls case People versus Cody Tournier.
Alexander on behalf of the people.
Good afternoon, Your Honor. Charlotte Steffen on behalf of Mr. Tournier. Excuse me, Tournier.
Cody Turner.
All right. What are we doing?
Your Honor, we are ready to set this for exam.
Okay. I don't necessarily have a problem. You see the new violation report.
Yes, Your Honor.
All right. What do you want to do about that?
Your Honor, he's acknowledging that he's in violation of his bond conditions. He does not have money for testing. He also doesn't have transportation for testing.
Oh, God.
Additionally, Your Honor, he has a medical condition
This ought to be good.
that causes him to have great anxiety under those testing circumstances, and historically has not been able to provide specimens, even if he had transportation and money.
So basically,
Well, except that on December 18th, he was able to do so.
by force, basically. I had to force myself to do that along with the rest of the tests. The last time that I went to go drop and do my test, my kidneys hurt so bad I almost felt like I was going to pass out, basically. My body just wouldn't let me.
Poor baby. He's pee shy.
Here's my problem. When I'm looking at this looks like somebody that just doesn't want to cooperate in the process. He tests, then telephones in right before Christmas saying that he didn't have the money to test. Then the next two tests that are scheduled, he just misses. Then the next test, it's an unable or refuse.
I'm not trying to play. I'm sorry if it looks that way.
I'm
Your Honor,
sorry.
could the prosecutor and I approach?
You may.
I don't want to embarrass myself anymore with this excuse in public. Yeah, that judge's face about says it. I don't know. Maybe. I mean, yeah, I can't make fun of the guy too much. I have difficulty peeing on command too, but... Oh, really? Syphilis. I didn't say it burns. Oh, maybe. Oh, the judge is laughing at his kidneys failing him. Oh no, the last time I told a doctor I couldn't pee, he tried to give me a prostate exam. Come on, Judge. We ain't got all day here.
Record to reflect the defense conference in this case. What I'm going to do in this case is I'm going to adjourn your probable cause conference out, check into alternatives to how to resolve this case. Would February 6th or 13th be better for you?
February 13th is a good day, Your Honor.
All right. February 13th, 2025. I'll set it at 9, but you'll get an invite with the time. And then with reference to his testing, at this point, I'm not going to violate the defendant on the report. What I'm going to do is I'm going to switch his testing And so you'll have to appear and they're going to do a swab. Okay. I usually don't do that, but I'm going to do that in this case because I really want you to test. Got it? Sure. Okay. And so we'll sign that order. Is that?
Transportation.
My girlfriend said she'd take.
Oh, we're off my bed.
Yeah. Got it. All right. So, and I don't know. You can check how many times he had it. So that order would be over there, and you may want to go over at this point. Do you know when your next test is supposed to be, or they
I
haven't called you?
been able to figure out from what I knew it was supposed to be this week, and I tried to test and it wasn't able.
All right. So here's what I'm going to want you to do. Since you're here on this campus right now, I want you to go over and see if they can get a swab in today. That way to start it out, and we'll send over the order. Okay?
Thank you, Judge. And one last thing.
Yes.
He missed a court date this morning with Judge Freshour.
God.
And she
He
said
did.
that perhaps we could address that with you while we were
Okay,
here.
not piss for her either.
He missed it this morning with her.
Yes, it's a separate matter. It's a
Do you
mystery.
have a case number on it? Let's see.
Yes, I do.
Let's take a look and see what they did.
It's 24F41587FY. Oh, I'm sorry.
No, that's us.
I'm sorry. It's 2440331 SM.
SM. Ooh.
I have no information about it's not updated. I can tell you it's a DD misdemeanor. It was scheduled at 9:30.
It's scheduled at 9:30 this morning. Okay. Can we get to Lindsay? Let's see if we can do something to reset him. You're counsel of record on that? Or-
I am, Your Honor.
Okay, so. Okay, if you give us a minute, she's gonna communicate with them. They're actually in the building.
Wonderful.
And let's see if we can.
They're in the
either
building.
Get it. If they issued a warrant to cancel the warrant, get him reset, and give you a date. Or if, at worst, give you the bond recall information and let you go through that process. But
Thank
let's
you
see
so
if we
much.
can shortcut that, okay? All right,
Come on.
thank you.
Come on.
Court calls case, People versus Charles Englehart.
Good.
Andrew Childers appearing on behalf of the people.
Appearing on behalf of my client. It's time we consent to the matter being heard via Zoom. Mr.
Englehart, can you state your name?
Charles Englehart.
I have a form that indicates he's going to be pleading guilty to illegal entry first offense, a 90-day charge. Upon his successful guilty plea to that charge, counts 1 and 2 would be dismissed. I also, as part of the agreement, it's okay for the defendant to seek HIDA.
That is correct, Your Honor. Thank you.
That is accurate, Your Honor.
All right, very good. Sir, can you please raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name again for the record.
Charles Englehart.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of breaking and entering or illegal entry first offense. That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right.
He also
Understanding all
broke
of that,
into the
you
house
still
that
wish to
way,
plead
too.
Guilty to this charge.
Yes, Your Honor.
And to the charge of breaking and entering illegal entry, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
All right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes.
If I can find my form here. On the date of December 15, 2023, at the location of 806 Hill Street, City of Ann Arbor, Washtenaw County, State of Michigan, what did you do on that date that makes you think that you're guilty?
I entered the property unlawfully.
Okay, when you say you entered the property, did you have anybody's permission to enter that property?
No, sir.
And I think it has to be a dwelling. Was this somebody's home?
Yes, sir.
It was
Or-
I believe it was a fraternity house. Your
It
Honor.
was a fraternity, but right, but
Yeah.
it has to be a dwell. Okay. All right. And you didn't have anybody's permission to enter that property, correct?
Correct.
All right. And you had no ownership interest or other authority to enter that property. Is that correct?
Correct.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count three. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this case will be
February 14th at 8:30 a.m. Judge Perry.
February 14, 2025, 8:30 before Judge Perry.
Judge, I have to inquire, is that the earliest possible date? I know that my client, he's currently going to U of M, and he has an opportunity regarding one of his classes, and I know that potentially he might have had to leave the state of Michigan. I was curious if there's any earlier date that I could get.
You'd have to call down to Judge Perry's office and see if there's an earlier date. That's the date they give us to
At least
give
it wasn't an
for
Idaho
sentencing
4
in this case.
situation.
Will do, Judge. I'm sorry, and that was February 14th at what time?
8:30.
Thank you, Judge.
All right. Thank you.
Oh, she said to recall. Okay.
It was a prank.
Okay. Is a swab test good enough? Can you ask because he's messed up on?
Let's see, then we can let them know I switched his testing from that to that, and is that acceptable? Court does call the case People versus Jamal Joseph.
Oh.
Andrew Childers appearing on behalf of the people.
I have no, Your Honor, Reese appearing with Jamal Joseph, who's present appearing on Zoom. Mr. Joseph, will you unmute and state your name?
Jamal Joseph Jr.
All right, thank you. All right, what are we doing?
Judge, I need some additional time to speak and negotiate with the prosecutor's office. I'm asking for another PCC date.
You're asking for an adjournment of this proceeding?
Yes, please.
All right, how much time are you guys gonna need? A few weeks?
Yeah, a few weeks should be fine.
All right. Probable cause conference, February 6, 2025, 9 a.m. or as your invite indicates.
Okay, thank you.
All right, bond will continue. Thank you. Yeah. Okay. You're checking with them on that.
Yes, I am.
Okay. Court does call the case of the people versus, is it Haoxiang Ho or Gao?
Don't call him ho.
No,
He, his, him.
Good afternoon, Your Honor.
Fee, fi, fo,
Orlando
fum.
Simone, Student Legal Services, on behalf and with Mr. Gao. Your Honor, Mr. Gao is present with me in my office.
God.
Gao, would you please state your name for the court?
Eozhen Gao.
All right. What are we doing on this?
The only thing I'm certain of is he's
Your
not a
Honor,
he, him.
I need some additional time. Ms. Hughes and I have had a few conversations, and I also need to be able to have another conversation with Mr. Gao's recently retained immigration attorney. So we're asking for another adjournment of the PCC.
Well, sir,
On the immigration
I have
issue,
some
are you
bad
gonna
news
need
on
more time
Tuesday.
In terms of that consultation, I just want to make sure.
Well, I know that Your Honor's been setting February 6th. If we could do any time there or after, that would be, I probably think, sufficient time.
After would be preferable.
I think so. Oh, that's right.
Correct.
National holiday.
Certainly is. Thank you.
Probable cause conference is February 13th. It's the holiday ended, is it? Okay. February 13th, 2025, 9 a.m. or as your Zoom invite indicates.
Very well. Thank you very much, Your Honor. Thank you, Ms. Hughes. We'll be in touch.
Thank you. Bond will continue with its conditions.
Enjoy the rest of your day, Your Honor.
Yes, sir. Thank you. Court does call the case of the People versus Olivia Stevenson Howard.
So you want to contact your immigration attorney, huh? Get out.
Right, but I didn't hear a prosecutor.
So what was the name of yours?
Oh, Stevens Howard.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Robert Goldman, PA 1222, appearing on behalf of defendant Olivia Stevenson Howard, present by way of Zoom this afternoon. Your Honor, we defense does consent to this proceeding being held to presume and thanks the court for its accommodations.
Very good. All right, what are we doing?
Your Honor, I am also going to be asking for an adjournment of the PCC. Today is a first PCC in this matter. I'm asking for an adjournment to further discuss with the prosecutor's office towards a resolution in this matter.
Without objection, February 6, 2025, 9 a.m. or as your invite indicates.
Thank you, Your Honor.
Thank you. Bond will continue.
Thomas Homan, Trump's
Thank you very
border
much.
guy.
Thank you. Court calls case People versus Alyssa Reese.
Ashley Lonnie for the people.
Good afternoon, Your Honor. William Amadeo, P76194, on behalf of Alyssa Reese. Alyssa, please state your name.
She's there, but
Alyssa
Reese.
It's Big Boy from last
all right.
time.
Need you to turn on your camera, please. All right, what are we doing? Well, she's trying to figure that out.
Your Honor, I do have the discovery from the people, but I'm having an issue with evidence.com. Me and Prosecutor Lundy are working through it. I'm asking for a 2-week adjournment.
Hold it. Evident not you're having issues with it?
I am.
What, it doesn't like you?
Well, join the club. But yeah, I don't think it's a big fan, Judge.
I was just thinking, I was wanted to make sure you weren't taking it personal.
No,
all right,
all
how
right.
much time did you guys need?
It's not as bad as my
I
whore
think
of an
2 weeks,
ex-wife.
Your Honor.
All right. Objection. Probable cause conference will be adjourned January 30th, 2025, 9 a.m. or as your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus James Worthington.
Good afternoon, Your Honor. Ellen Michaels on behalf of James Worthington. My P number is 67943. Mr. Worthington is present in court.
All right. Your name, sir?
James Worthington.
All right. Very good. All right.
So today's a date time set for our second probable cause conference. We'd adjourned it in order to get all the Child Advocacy Center videos. I'm short 2 videos, though I've been notified that they have been sent to me. So I believe we're ready to set it for exam, assuming that they in fact were uploaded today as stated by the prosecutor.
For clarification purposes, I have confirmation from the detective, the officer in charge, that they have just as of today been shared and made available on evidence.com. I've relayed that information to the proper individual in our office, I would expect that those will still be shared with council before the day is over. But just to be clear for the record.
All right. And if those are done, then discovery is complete.
Yes.
Yes.
Don't like to do it this way, but I get what you're saying, that it's there.
Understood, Your Honor. Thank you.
If there is a problem, I will bring it to the court's attention and file the appropriate stipulated motion in order.
Right, but that's what we try to give people time at PCC to get all that stuff straight and not set something and then have it adjourn out. So
Understood.
I want to make sure that we're going to be able to go forward. People had their witnesses available the 28th
28th of
January.
what time?
9 a.m.
Oh, I'm not available at all that day. I have a 9 a.m. exam and a 12:30 sentencing.
February 4th
Checking.
or February 11th.
What time? February 4th, 9 a.m.?
No, they're all at 9 a.m.
February 11th. February 11th is good.
Preliminary examination in person, February 11th, 2025, 9 a.m. before. Is it available? Am I ahead on that list? Okay. Before Judge Valvo.
I didn't hear the name. What name?
Valvo,
Thank you.
bond will continue.
I'm asking Your Honor to again revisit the bond conditions. What I'm simply asking is that my client be reunited with his children. He does not need to go back to the residence that's across the street from where the complainant lives. The family can stay with a friend in a separate location, but since the incident that the two children of my client have been taken away, even though CPS has not filed the case has been closed. There's no issues. The children are staying with grandparents, and this has been going on since early December.
Your Honor, people continue to object to that. Again, as I indicated the last time you were here with the same request, I get that. I really do. I'm not comfortable agreeing to that because although I understand that defendant's daughter was interviewed at the CAC and did not disclose. That being said, our charged victim, her first trial best friend, in her CAC interview, where she made all of her disclosures, she indicated that his daughter also told her that she had been sexually assaulted, both by defendant and by their son, as well. So I am concerned. I'm not willing or able to agree to change those bond conditions. Understanding, obviously, ultimately it's up to the court, but I am concerned for the safety of any minor child.
And I'm quite frankly, counsel, I'm in the same position I was the last time, I think, that I don't think anything's changed, and I denied the request the last time, and I don't have any additional information that would lead me in that other direction. So I'm going to decline. I'm not going to change its bond conditions.
Can I just make a record on one matter?
Sure.
Thank you so much. My client's daughter, Lila, who the prosecutor was talking about, she was taken by the police to University of Michigan Hospital and physically examined. There's no indication of any sexual assault. She was also, as stated, interviewed in a forensic.
Ma'am. All I'm hearing right now I know, innocent until proven guilty.
Forensic setting and did not make any disclosures. We believe this is all part of these are all false allegations, and the children, there's no evidence that his children have been assaulted in any way. This is part of the discovery that was tendered to me by the prosecutor, the medical records and her interview.
Judge, as I indicated last time, same record was made then, same arguments were made then.
I know.
Certainly the court has been doing this as long as I have been doing this. There aren't hardly ever medical findings when a small child has been sexually assaulted. It's all about timing. It's all about type of sexual assault. It's all about those areas of our bodies being fast healing. It's all about so many moving parts that a lack of medical information means zero things in terms of whether or not a child has been sexually assaulted.
One more thing, Judge, that the allegations are that the daughter allegedly said that my client penetrated her every single day. There would certainly be medical evidence of that. Thank you.
It would not necessarily be. Penetration can be a whole lot of things with a whole lot.
Yes. And again, I know you made your record, but I'm still at this point going to deny that. Judge Valvo, after damn happens, may feel differently, and certainly you can bring that before her.
What was the
But
name,
This
Kay?
time I'm going to deny the request. God will continue.
Thank you very much.
Thank you.
Thank you.
Do you remember the name? I can go back if you don't have it quickly. I want to pull this up. James Worthington. Thank you. Worthington. Let me type this in. I'm used to Fleischer's court, which is all misdemeanors. So none of those misdemeanors don't really make the news very much. Unless it's my friend committing some criminal mischief with Christmas decor during the holiday season. Then he's known as the Grinch, Christmas Grinch. But let's see. So his name was James Worthington, you said? Oh, it's court records. That's why. Okay. That'll take me a little longer, but okay. Me too, but my bookmarks aren't nearly organized well enough.
How's the case of People versus Christopher Jordan?
As one of the people.
Good afternoon, Judge. E8 Ward 261 here on behalf of the prosecution.
All right.
Who is not present.
Who's not present?
If you can, send me the link quickly. No pressure.
I was wondering maybe we could do this without him.
Or I can look it up.
Not for long, we can.
Your Honor, I know the court has received the
Violation.
bond violation report from community corrections indicating that no tests from therapeutics have been sent over, and defense counsel was kind enough to provide correspondence from therapeutics dated yesterday, indicating that the defendant had been doing some meetings and some other things with therapeutics. But as I looked through that paperwork, I wasn't able to see a record of any drug testing.
Testing.
So I'm not sure if I missed something. It's certainly possible, but I didn't see anything in that correspondence that had that in there.
It's, sorry to interrupt. It's on the top of,
I didn't see.
on the top of the second page, client is in phase 1. He provides UDS, urinary drug sample.
But it doesn't include testing results.
Yeah, that's right. I figured there would be some testing component to it, but I don't know where are the results of those tests?
I don't have the results of the tests. Therapeutics, I understand, is doing the testing and continuing to provide Mr. Jordan with the methadone that is part of his treatment.
Okay, but are they sending the test to our community corrections?
Unfortunately, it seems that they are not. So I don't have the results, but I do have record that Mr. Jordan is in treatment. He is living homeless, as I was explaining to opposing counsel.
Oh, thank you.
He's avails himself of a lot of resources here. There are two volunteer social workers from the warming center that asked me to step into the case. I'm on this case pro bono. So Mr. Jordan is in treatment, and I apologize to the court that I don't have the records of the drug, the sort of results of the drug testing, but he's availing himself of treatment. He's in, he's attending these meetings, both individual counseling sessions and group meetings. And the other thing that I think is relevant to the court is Mr. Jordan, this is a case from 2022, 2.5 years ago. And there's a more recent case. He was charged with a misdemeanor, and we resolved that last year with the prosecutor's office dismissing the case pursuant to Mr. Jordan being in treatment, which he's still in treatment. And so it feels a little counterintuitive that we dismissed a more recent case for Mr. Jordan's compliance with treatment, which he's remaining in compliance with. And we've now charged him with a felony from 2.5 years ago. I'd ask the court.
So you should say the prosecutor should not do that kind of thing where, I mean, if they've got to be intuitive, that means everybody should get charged and just go for it. Never mind. Go ahead.
I'm asking that the court, because this case also involves an extremely questionable stop by the police and search of Mr. Jordan as he's walking down the street or jogging down the street. I'm asking that the court, before a warrant is issued on such an old case where there is a questionable, there is, I argue, a Fourth Amendment violation.
Okay, I get that. If he got here, then we could have the hearing on all of that.
Yes.
But he's not here.
Understand, he's ill, he's living homeless, it's been extremely cold outside. He's managed to continue to get himself into treatment. So I'm just asking that the court hold off on a warrant and allow us to litigate the legitimacy of this arrest without a warrant issuing.
Well, I'm going to issue a bench warrant for his failure to appear at this proceeding. And I mean, I might not do that if I had test results coming in, given the circumstances, but
Suboxone is basically the newer version of methadone. Definitely insurance. When I started taking it in 2010, it was super expensive. Without insurance, minimum $150 a month. But it's gotten a lot cheaper. The nice thing about Suboxone is it comes mixed with naloxone, so you can't take Suboxone and then go and take oxycodone at the same time because you won't get the high. They have melt away. They're like, the ones I'm familiar with are like the Listerine strips you put under your tongue, and then those kind of melt away. It worked well for me. I don't know why you would take it if possible. I was on it for a lot longer than that. But yeah, I weaned off it myself and just very, very slowly. And I was fine. I was on it for almost 10 years. Long story. But the only hard part for me was like the psychological effect of being used to taking it. But physically, I like the taste. Me? Y'all were doing drugs? When I was 18, yeah. I was addicted to pain pills for, I don't know, like a year. And then realized I had an addiction and got help. Yay.
None of this really puts a picture together for me of where the defendant is or what he's doing.
That was the first one I had.
Not testing. So, I'm going to issue a bench warrant. Bond will be set in the amount of $25,000 cash surety. If you locate him and if you get him in, there's a warrant recall procedure you can go through on this. That warrant will issue immediately. Thank you. Oh, you did another. Got it. Okay. Because I finished up these other. All right. Clerk calls the case of People versus Tournier 2440331.
Haley's on behalf of the people.
Good afternoon, Your Honor. Charlotte Steffen on behalf of Mr. Tournier.
Okay.
Mr. Tournier.
All right. So what we've done, this is on the case that is before Judge Freshour. Bench warrant was issued. I'm going to recall the bench warrant on that. We spoke with Judge Freshour's chambers. I will reset his hearing to January 30th, 2025 at 9 a.m. before Judge Freshour. I'm setting aside the warrant, but he must test with community corrections. He probably can't make it today. Well, maybe he'll still get in today. I think they close at 4:30. Okay, sorry. So I'll have to come back another day.
I'll do it tomorrow.
But we got your warrant set aside.
I do have a question.
And what I also did is we checked with Judge Freshour. The oral testing is also appropriate or is sufficient in this case so that we don't have to go through all of that.
Thank you, Judge.
Yes, sir.
Is it costly? The mouth swab.
There will be a cost to it.
I just need to know how much so I can figure it out by tomorrow.
Do you know how much the oral testing is? Anybody?
Sorry?
Oral testing at community corrections? Yeah.
30, somewhere in there, I think.
Yeah, it's more
It's a more expensive test.
than the urine test. All right. Here's what you do. Get yourself done. You got to do that within 24 hours. Okay. So get that money together, get down here tomorrow if you can and get a test done.
Sure.
Okay. And get the first one in and then try to work it through as to how you're going to do each one per week. Okay.
All right.
All right. But make sure to get that one in so it doesn't look like you're just avoiding it.
Sure.
It's $20. Okay.
Thank you, Your Honor.
You're welcome, sir.
Thank you, Judge.
You're welcome.
Yeah.
Oh, he's not here. Court does call the cases of the People versus Alan Maloney.
For the people.
On these cases, Mr. Stringer is not here. Mr. Stringer did contact our office.
Yes, Your Honor, he contacted me as well, and I'm aware of his difficulties to send.
Yes,
And I
okay.
just told him that to not be concerned with this hearing, I would request a new date on his behalf and I understand his client is not here.
Yes. So, I don't know how long. All right, let me adjourn it out a couple weeks, okay? So, probable cause conference, January 30th, 2025, 9 a.m. or sure, as the invite indicates. Bond will continue.
Is it a week, Your Honor?
Two.
Two, thank
I
you.
did the 30th. Right in.
Yes, sir, that's it for the day.
All right, I'm not moving anywhere. 14A. Stands adjourned.
All right. I'll do a little bit more. Maybe. I think this was the other one.
We're making progress.
You wouldn't know.
Thank you.
24.
Okay. All right.
25.
We'll be in touch.
I knew that.
Do you need a paper? February 3rd.
At 9, you know what? I don't hear it anymore. Fine, continue. Thank you. Court calls case people versus Christopher Waldecker.
Let me look half Irish.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Waldecker, who's approaching now. Will you please state the record?
Christopher James Waldecker.
Thank you, sir.
We would ask for an adjournment for some continued plea negotiations.
This whole docket has been green sheet.
We're making progress.
You wouldn't know from today. How much more time did you need for these negotiations?
Talk to your officers, a couple weeks? 2 weeks, Your Honor.
Probable cause conference, January 30th, 2025, 9 a.m. Thank
Looks
you.
like he has a
Continue.
Thank you.
sir.
preliminary examination in February 11th.
This doesn't have a green sheet. I guess I'll do that. Court calls the case of the people versus Tiffany Simmons.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Tiffany Simmons, who's approaching.
Hi, I'm Tiffany Simmons, sir.
Thank you.
You're welcome.
Discovery is complete, Your Honor.
Thank you for Mr. Burgess for actually calling my office, letting us know you were delayed.
Oh, no problem.
And telling us approximate time that you'd be here. That was very much appreciated.
And I think it was in like a minute. It was like not even lawyer time, Judge. It was actual.
I know, it was actual time that you were given. No, and we appreciate it.
No problem, Your Honor.
The court didn't get that same respect this morning.
Oh, I wasn't on your docket this morning.
I know, I'm particularly sensitive. All right. So you guys are ready for exam?
Thank you, Judge.
People have their witnesses available on the 20.
Now we need to follow it. Yeah, I know. Like, we're getting way too many cases to follow here. I'm still keeping track on the Buster Robbins case from the 16th. The 35-year-old cold case. Oh, why are the comments covering me up now? That's weird. I talked to David about it. He had not heard. I'm gonna have to get an Outlook calendar. I have to get a calendar and be all professional. So I talked to David. He is going to try to go. Well, the next hearing is on the 30th, and that's just a probable cause conference. So if they get the discovery in time, which hopefully they should, police have had 35 years to do it. They'll schedule when the probable cause conference is. So David said he would try to pop in for that if available. I requested the police records and everything today, so I'm hoping they'll get back to me and I can get some of that and figure out what's going on. But I'm definitely following it.
We'll do our best, Your Honor.
Preliminary examination in person, January 28th, 2025, 9 a.m. before Judge Washington.
Oh, I did go to Satan's armpit, known as Reddit, and some other podcaster has been following another missing person case in Michigan. She doesn't think they're related because they're kind of further apart. But anyways, they were talking about Beverly Wyville and like somebody's friend's mother. It was somebody's friend's mother commented. But that's about it. No, not Elkins. Paige Renkowski from June of 1990. I think she's missing. Yeah, still missing Paige Renkowski, so she was never found. But it was much further away. So Okay, Mavka. Is that a recent one? And hi, Sasha. I'm good. How are you?
Thank you, Your Honor.
Thank you. Bond continued. Thank you, Ms. Simmons. Court calls the case People versus Aaron Washington.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Washington. Will you please state your name for the record?
Aaron Washington. Thank you. Good afternoon. Good afternoon, sir. You're requesting an adjournment.
Please, Your Honor.
Okay. Where are those other things in process, do you know, and how long?
Did you get my message?
No, I don't think so.
Okay.
I probably did. I did not read.
Wow.
Been waiting on my office to review a new case for Mr. Washington. I've been waiting for the police to submit it. Finally, today I found out it's actually not our case. It's like a township prosecutor's case, and it's under review there. So I
cannot say how long. Got it.
I'll sit down.
All right. But you still may want to try to wrap it into whatever you're.
Ideally, yes.
All right. Let's go to February 13th, 2025, 9 a.m. Bond continued.
Judge, I'm sorry, I missed that date.
13th.
13th. Thank you.
Yeah. Oh, I was talking to you. I'm
13th.
sorry.
No, you're
Okay. Thank you, sir. Court does call the case. People versus Hannah Wellman.
Andrew Childers appearing on behalf of the people.
Ashley Moten, Assistant Public Defender, appearing on behalf of Ms. Wellman. State your name. Sit right here.
Hannah Wellman.
All right. This is a waiver.
Yes.
Ms. Wellman, you're going to waive your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
We waive formal reading of the information and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 12th at 1:30 before Judge Conlon.
March 12th, 2025, 1:30, Judge Conlon.
Okay. Thank you.
Bond will continue in this matter. Court calls case People versus Madison Wellson.
And on behalf of Mr. Wellson, who's appearing to my right. Please state your name for the record.
Madison Wellson.
Andrew Childers appearing on behalf of the people.
At this time, we would like to ask for a 30-day adjournment, Your Honor.
Why?
Seeking mitigation information,
That's not what this says.
proof of treatment.
So is he in treatment now?
He is, Your Honor, and we're just
All right,
waiting
you're just
for
looking
treatment.
for time to see
Yes,
how
Your Honor.
he's. That's what you meant to say.
Yes, that's what I said.
Wow. She wouldn't listen to how. No, she says exactly what's on her mind. It's gonna get her in trouble, but she says what's on her mind. All right. So how far along are you in treatment? How long have you been in?
I want to say the week after I got out of jail, I enrolled into IHA Medical.
Okay.
And then I'm attending AA meetings, paying my supervision fees. So I'm pretty sure I've been in there this whole time.
Okay.
My scripts every month.
Got it.
I see my doctor once a month.
Once a month? Okay. So why don't we do this? Let's,
And I do drug tests with her also.
Pardon?
I drug test with her also.
Her also.
Top of community corrections.
All right. Probable cause conference, February 20th, 2025, 9 a.m. Okay?
Thank you, Your Honor.
All right, good luck to you, sir.
No, I'm not gonna give him crap, apart from the hoodie.
Court calls case People versus Ryan Wheeler.
Ashley Lottie for the people.
Hannah Mackey on behalf of Mr. Wheeler.
He's making
Bring to my
progress,
right.
so good for him.
Please state your name for the record.
Ryan Wheeler.
All right. And of course you are. This is just for straight plea negotiation. Probable cause conference
Well,
without
you
objection.
could think he doesn't need it.
Will be adjourned January 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
What time?
9 a.m.
He can quit
Okay.
anytime he wants.
Okay,
He
thank you.
chooses not to.
Have a
Court-
good day, Your Honor.
Is that it for you?
I think you're coming to my school tomorrow, though.
What?
I thought you
Oh.
were at my school.
Oh, so hold it. I am, but I thought I was supposed to be giving an oath. You haven't taken the oath?
No, not for me, for my friends were telling me that you were coming to the court, to our school.
Oh. You won't be? Okay, then I'm going. No. Court calls the case of the People versus Edward White.
Did you just find out what he's doing tomorrow?
Public Defender Fellow Nicholas Berkovich on behalf of Mr. White. Mr. White, can you state your name for the record?
White.
Can you state your name again?
At this time, Your Honor, we'll be setting this matter for a preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available the 28th. Preliminary examination in person, January 28th, 2025, 9 a.m. before Judge Barr. Court does call the case People versus Ernest Zazar.
Assistant Public Defender Asli Bashir on behalf of Mr. Zazar.
Ernest Zazar.
Zazar.
How you doing, man?
I'm doing great, thank you.
Uh,
All right, what are we doing?
We request an adjournment for further negotiations with the prosecutor.
Probable cause conference will be adjourned January 30th, 2025, 9 a.m.
Oh, Your Honor, if we could request a longer adjournment, we also need to collect some mitigation information. So would it be possible to request an adjournment of
6 weeks?
or 4 weeks? We could do
6 weeks? Is that what she said? She said 6 weeks?
Hey, Benjamin.
Alternatively,
6 weeks.
Your Honor, I believe.
Who told you to ask for 6 weeks? See, Akinruli said some things. So why are you requesting 6 weeks?
It was a determination based on my own judgment, but I would defer, of course, to Your Honor, as it's your decision.
That was that Yale speak. February 13th, 2025, 9 a.m.
Thank you, Your Honor.
You and Akinruli are up to something.
No.
Oh, no.
No, you
Not you. You're good.
This is all on me. This is all.
What? No, it was not all you. Akinruli's doing something. I don't know what it is. Court calls the case People versus Simmit.
Oh, I love he just knows. I'll have
Good
to check
afternoon,
out
Your
live.
Honor. Deborah Schlossel on behalf of the defendant, Mr. Eric Simmit, who is approaching police station.
Eric Simmit. All right. Good afternoon. All right. What are we doing?
Your Honor, I am freshly new to the case, so I am asking that we adjourn this matter a few weeks so I can get discovery and go over it with my client.
January 30th, 2025, 9 a.m. Bond will continue. Thank you, sir.
Thank you. Sir.
I don't think I've seen you, counsel, so Happy New Year.
Well, thank you. Happy New Year. You know what, Your Honor, may I ask?
Oh, God, it's the
Is it
18th,
possible to
sir.
ask on the record to do Zoom?
Sure, you can ask. I don't have an answer.
Okay.
You can submit the
Sasha.
form. Thank you. Court recalls the case, People versus Barage Scott. There he is.
There was actually the other day I was going to do a very Indian heavy segment of Judge Simpson. And it would have been great and very funny, but then it turned into a kid killed this Indian husband's wife. And it was just turned into a huge bummer. Sweet Jesus. Yay, Amber. Who's the father, Elon Musk?
On behalf of the people.
Assistant Public Defender Ashley Bashir on behalf of Mr. Scott,
Barage Scott.
or Ante Scott.
Thank you. All right. You're requesting a 2-week adjournment?
Yes, sir. For further negotiation.
That objection, probable cause conference will be adjourned January 30th.
January 30th?
Yeah.
I got a dentist appointment on that day. I got to go get my teeth fixed.
Um,
My tooth fell out.
Oh, I'm sorry.
When I was drinking a Vernus, it fell out.
When you were what?
Drinking a Vernus, it fell out. Remember, it was loose last year.
Oh, yeah, I remember. All right, let's go.
Does he?
So you'll be good in a week after that?
Yeah. Yes, sir.
All right. So what we'll do is we'll set it for February 6th, 2025, 9 a.m. Okay, so the following week after, Mr. Scott.
Thank you, Your Honor. And also, I'd like to correct my statement. The reason for the adjournment is to advise my client on the outcome of negotiations, not for further ones.
Gotcha. Okay. All right. Take care, Mr. Scott. That is for us. 14 days stands adjourned.
All rise.
Bye, Fran. She can pledge you 500K.
Your lips are dry, actually.
I'm not gonna.
There are alternate solutions.
I'm not gonna use branded chip.
Scroll.
Matt?
Yes, we're talking on the Lewis matter. And I think, Madam Attorney General, you were here.
Yes, Your Honor. Benita Hoffman on behalf of the people. I'm an Assistant Attorney General, and I have spoken with opposing counsel regarding this. There are 2 co-defendants. One is Alice Elliott. She's also charged with a felony. And then the other one, Josiah Walker, is charged with a misdemeanor. And those are scheduled, I believe Alice Elliott is scheduled for arraignment next week, Your Honor.
Okay. So, do you see that one?
I see that the file went to magistrate, I think on the 16th. I don't show that arraignment was set in January. So it's possible to do that. I can confirm with her.
Pardon?
I can try to confirm with that.
Hold on.
No, wait.
Hold on.
Wait a second.
Hold on 1 second.
Seeing if any of those folks were actually here, we could arraign them right now, but they're not here.
Well, part of what I'm concerned about is how these got separated in some respect, but I think I know how that happened, because I think one was flagged for whatever reason as a potential bond violation, and why it then came to me, but then determined not to be.
Correct.
And then, what are you looking?
It looks like Miss Alice Elliott is represented by an attorney who filed a bench warrant recall form on her behalf. the magistrate's office is trying to arrange the trial tomorrow.
Tomorrow. Okay. And that's a felony charge.
Yes, I'm listening.
That was a misdemeanor complaint, so likely that's gonna go to 15. So I got enough problems here. I'm not gonna deal with that. Okay. So what date? Well, the prelims are on February 12th. Okay. All right. We'll get to that at some point. All right. Court does call the case of the People's State of Michigan versus Samantha Lewis.
Good afternoon, Your Honor. Bonita Hoffman, Assistant Attorney General on behalf of the people.
Thank you. Good afternoon, Your Honor. Good afternoon to your staff. My name is Amir Macklett. I represent Ms. Samantha Lewis, who's president, standing to my right.
State your name, please.
Samantha Lewis.
Thank you. All right. This is an arraignment on 2 charges. One, resisting and obstructing and assaulting a police officer, and they charge a carry along of trespass. Counsel, do you wish a formal reading of the complaint, or do you?
Thank you. Respectfully, Judge, I'd ask the court to waive the formal reading of the complaint. Ms. Lewis understands the charges before her and will stand mute to both counts.
All right. Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. I will set this for a probable cause conference, and typically, as you know, our practice, we set the probable cause conference, and then the exam comes along, so I won't be giving you an exam date. But I guess here's my question. I currently have the other matters that are set for exam February 12th, correct?
That's correct.
All right. So is this going to be something that is separate from those? Or
yes, they're different days.
Yes.
It's a different protest. So different facts, different witnesses.
Different days. Okay.
It's still the same, essentially the same witnesses. It's the U of M Police Department. But yeah, they are separate facts and separate dates.
Separate officers, even.
There? I don't know. Oh, well, here's what I was just trying to figure out. Does it make sense to set this for, I'll set it for a PCC, but is it likely that this would end up on the 12th or not?
I don't think we'll have an exam on the 12th for this particular case, not with as many co-defendants as we have on the other case. I think that exam will run for, quite a while, just because there's 5 or 6 co-defendants.
I'm aware of it, but what I'm saying is it going to make sense because of the nature of the activities to put them all together? I'm not so much concerned about the witnesses, but one of the things I'm concerned about is Ms. Lewis coming here. She'd have to come for a PCC on this, then come back for the exam on the other matter. And I just, I'm just looking to try to make it as convenient as I can for everyone. But, if nobody wants to do that, I won't.
On the 12th.
Pardon?
We'll waive the 21-day rule, set the PCC on the 12th. That way the other.
That's a special date that I've set for the exam because I've got, I think, 8 co-defendants. So.
I'm at your discretion, Your Honor.
Well, I can just set this in the normal course, but I don't know if that inconveniences everyone in terms of doing it. That's all I was trying to do. I mean, I don't have to try to be nice about it, but I'm trying.
If we could set it, let's keep the 12th date if we can, Judge. I think that helps because I know my calendar's clear on the 12th. I know.
Well, the 12th will happen.
Right.
Where do you want me to put this case? That's what I'm asking.
We could, if it's the same witnesses, let's put it on the 12th, maybe right after.
For an exam, or you want a PCC before it and then make a determination as to we put it to the 12th?
Sure.
Would that make sense, Madam Attorney General?
Yes, I think that's fine.
All right. So what I'll do is I'll just set a probable cause conference in this case I can do a probable cause next week on the 23rd if that works.
If we could have it in the afternoon, it would work for me, Judge.
If you'll give me one moment, I'll check my schedule, Your Honor.
Okay. I'm here all day, so I'm good.
Yes, the 23rd. I have a sentencing in 15th District Court at 2 p.m.
No, wait. No, I'm kidding. Okay, so you have a sentencing at 2 in the afternoon at 15 on that.
Yes, in front of Judge Valvo.
Got it.
It's on another co-defendant. No, not a co-defendant, excuse me, another protester.
Got it. And you need the afternoon.
That's correct.
We have a 12:30 block. Okay. Then, here's what I'll do then. I'll set a probable cause conference for January 23rd, 2025 at 12:30. Timelines having been waived, then we'll figure out, after looking at everything, where this one will go. from there. All right. Any issues regarding bond on this case?
Your Honor, with respect to bond, we are asking that you not have any contact with the University of Michigan's properties or any of the University of Michigan property or students except as necessary for medical care. We're asking that you refrain from any assaultive conduct. We're asking that you not have any contact with the Tahrir Coalition, which is an organization.
I'm sorry?
Tahrir, Tahrir Coalition.
Okay.
And that you not have any contact with Alice Elliott or Josiah Walker.
Assuming a recommendation of PR bond?
Oh, yes, that's fine.
And it's Josiah, you said Walker?
Yes, Your Honor.
Counsel, any response to the condition request?
We don't object to personal recognizance bond, Judge. Ms. Lewis obviously has ties to the community and substantial support as evidence in the courtroom. I do have a strong objection to any prior restraint to this coalition or organizing or being a member or associated with the Tahrir Coalition. I don't know what the Tahrir Coalition is. According to the Attorney General in my conversation with her, she says it's a group that protests. Well, I don't think that the court rule 6.106 has any condition that would impose a prior restraint when it comes to bond. It's a
well, that's not true. Because I mean, I heard this argument when I was reviewing the bond. Many times, bond is about prior restraint. If you're going to look at the definition of prior restraint, so I mean, I don't know that is a compelling argument for the court.
Well, I think the association it's another right that an individual has. A citizen has the right to associate, to organize, and to have meetings with other individuals. This coalition, whatever the coalition stands for, does, or whatever activity they do, I don't think it's necessary as a condition of her bond. I think that it becomes an imposition that is not, it's a set of standards that doesn't happen in any other case. This is a situation, it's not part of her bond condition in the other case that we have pending before this court. I don't have an objection to not going to the University of Michigan except for medical purposes. No problem there.
Let me just ask this. Is she a student at the university?
No, not currently.
Okay. So let me also then I guess ask the question, would there be any reason, so there's no reason that she would need to go to the University of Michigan except if it were
for medical
purposes along those lines, right?
Correct, that's correct.
Okay. I see that her address is a Detroit address.
That's correct.
That's correct. Okay. So is there any reason that she would need to be in Washtenaw County? And I'll tell you why I'm asking that. It may seem broad, but I also don't believe in placing individuals in positions where they may violate a condition of bond and not now. If it were easy, even for those of us that reside in this county, to figure out exactly where University of Michigan property is, then I wouldn't have a problem. But you could be walking along and all of a sudden you could find yourself on U of M property, not necessarily meaning to, but then in at least technical language violating the bond conditions. So I try to set parameters that may seem rather restrictive, but also are clear for defendants. And one of the other things certainly let you talk. The other thing is I could not do, for example, I can't say Ann Arbor because University of Michigan properties exist within Washtenaw County, outside of the city of Ann Arbor.
Well, Judge, there's campuses in Flint, there's campuses in Dearborn. There's.
No, I know, but I'm more worried about here right now. I can't. My wonderful colleagues around the state can worry about those other places. I just have to worry about here. So,
Judge, she has ties to Washtenaw County. If the court's thinking about imposing that, she does have ties to Washtenaw. So I don't know where the court would like to go in terms of imposing a no contact order with the county of Washtenaw. She has ties here. Familial ties, personal ties, friendship ties, work associated ties.
Aw, she has the power of friendship on her side.
Is it Tahrir Coalition?
So I don't.
Go ahead.
The information that we have in our files is that the Tahrir Coalition is a professional organizing group that advocates for pro-Palestinian policies. And we don't have a problem with the fact that it exists or that it advocates, but Ms. Lewis's involvement with that group has so far resulted in 2 arrests for her that have resulted in charges for resisting and opposing a police officer. And for that reason, we're concerned about the contact that she has with them and the work that she does on their behalf, because it is leading to that kind of assaultive behavior.
But are you indicating that her connection to the group, that she somehow is causing others in the group to act in a certain way, or that by her being part of the group, she's now acting in a certain way? I guess I'm unclear as to that.
Sure, Your Honor. I don't know if the group is causing her or if she's causing the members of the group to behave the way that
No,
they're behaving.
it's
But
both,
in the last
ma'am.
case, the juvenile was arrested for resisting and opposing as well. We elected not to charge her, but there was a juvenile that was involved in this particular protest. She was sort of the ringleader. She was the one that had the loudspeaker. She spoke over the officer who was trying to get the people to disperse and put
Oh.
down signs that they had pointed edges on the sticks. And then she resisted the police officers when they went to arrest her. So our position on it is, I don't know if she's the cause or if she's caused, but either way, she's behaving inappropriately. If she was just speaking, no problem.
Wait, so is the leader
Right,
the
but
one with the
outside of the
bullhorn?
behavior that different sides may disagree on, I'm trying to figure out if
How we
what
can
the
shut her up?
correlation is between the behavior that is alleged and her participation or alleged participation with this group or coalition. I'm not following it, I guess.
Your Honor, I understand the court's concerns, and in light of the fact that she could do work with the organization, I would rephrase my request to be that she not be involved in any protests with the organization.
So
Judge, we're not coming to camp.
Hold on before you go, because I'm sure you've got a lot to say on that.
I do.
Yeah. Well, again, maybe you have to help me. Is it this To Hear coalition that is responsible for the protest? Is that the piece I'm missing?
That's what we believe to be the case, Your Honor.
Doesn't look Jewish, Mavka.
Okay. And so, again, so that I'm clear, that the To Hear coalition is alleged, or at least thought to be responsible for the protest. And so you want to restrict this individual's participation with that group because of their responsibility for organizing the protests that have led to this.
That's correct.
Okay. All right. At least understand their position. Maybe I agree, don't agree, but go ahead.
Very well. Thank you, Judge. Respectfully. The defense, and the court is no surprise, the defense is this is free speech, that these are protests, and that this is indicated that she's presumed innocent until proven guilty from the very outrageous, ridiculous, and
Save it
with
for
no
trial,
merit to the charges
counselor.
that she's brought now twice. Okay, this is going to be very litigated. Her position is
Wonderful.
that she's not guilty.
Save it for the jury.
And that she's going to be presumed innocent until proven guilty. The bond conditions, Judge, are supposed to be set so that somebody comes before this court and that there's community safety and other provisions that we've already accomplished one provision of safety for the community. She's not going back to campus. Nothing associated with the University of Michigan. We agree. The further condition of association with Tahrir Coalition, whether or not they're the reason for this group that organizes protest or not, that's, to me, I don't think that they are. I think that the reason why these protests occurred is because the genocide that was happening in Gaza.
Oh,
so
Jesus.
whether it's the Tahrir organization, Students for Justice in Palestine, any other of the dozens and dozens of groups that are standing and against what the purpose
Your
of that
Honor,
protest,
Trump already
they
fixed
could have
that
been
problem,
associated
so
with as
she's
well,
not
with
going
these
to do any
protests.
more
You
protesting.
can't just pick one group and say you can't be a part of that because we believe with no evidence. It's just it's a summarily stated statement by the AG at this point that she can't associate with it. It doesn't have any reason or purpose in a bond condition. It's not necessary. We're not going to campus. We're not going to have any more protests. She's not protesting. There's a ceasefire, thankfully, that we've heard of.
Is the protest
So I
in the
think
room
that
with
the
us right
situation
now?
has calmed down a bit.
Holy shit, he actually
However,
referenced
it's not
that.
necessary at this point, Judge. And 6.106 it's not required.
He actually
When we
said
get
there's
to
a
the other issues
ceasefire
of
now.
no contact with the co-defendants. Judge, we have joint defense agreements in this case. With
I
the
was
in the other
making
case, I
that
don't know if
up.
we're going to do the same in this case. But the lawyers will be communicating. And there's going to be time when our clients are going to be in rooms with the co-defendants while we're communicating defense in this case. I'm letting the court know that from now. We've been in talks. and we're going to continue to talk to defend our clients. So outside of that, no problem. We're not going to have contact. But I just want to make the court aware that there are joint defenses in this case.
And I'd like to
understand
thank
that,
Donald
and
Trump
I
for that.
don't think that court's
Come on.
order would in any way be interpreted to cover the scenario that you're indicating.
Thank you, Judge.
I mean, I don't think it could. So that's the first part of that. The other part, though, is
Yeah.
anything else from either side?
Your Honor, I didn't hear the last thing that the court said. I'm sorry.
I said, was there anything else from
No,
either
before
side?
that.
No, Your Honor.
Can we get one more? Free Palestine.
I will indicate that I'll set the defendant's bond at $10,000 personal recovery.
Chubby woman joined a Free Palestine group, and they were arguing over her conditions for release and where she has to stay away from. And her lawyer said that since there was a ceasefire now in Gaza, that she's not going to protest anymore. Well, that's true. Because she got arrested for protesting. These crazy people. All right, I think I'm going to end here, guys. It has been a lot of fun. Let's see. Yeah, I think I am. I may stream tomorrow, but probably not. But I'll probably be back Monday. So, thanks everybody for being here. It's been a lot of fun. Free Palestine. And I hope to see you guys soon. Toodles. I hit leave studio again. I caught myself. End stream. And since somebody bitched about an outro video last time, let's see, what do we got?